Air Canada has been forced to give a refund to a passenger after its chatbot agreed to it. Let's take a look. In this civil resolution tribunal, Moffatt v. Air Canada from 2024, this dispute is about a refund for a bereavement fare. In November of 2022, following the death of their grandmother, Jake Moffatt booked a flight with Air Canada. While researching flights, Mr. Moffatt used a chatbot on Air Canada's website. The chatbot suggested Mr. Moffatt could apply for bereavement fares retroactively. Mr. Moffatt later learned from Air Canada employees that Air Canada did not permit retroactive applications. Mr. Moffatt says Air Canada must provide them with a partial refund of the ticket price as they relied upon the chatbot's advice. They claim $880 for what they say is the difference in price between the regular and the alleged bereavement fares. Air Canada says Mr. Moffatt did not follow the proper procedure to request bereavement fares and cannot claim them retroactively. Air Canada says it cannot be held liable for the information provided by the chatbot. Finally, it relies on certain contractual terms from its domestic tariff. Air Canada asks me to dismiss Mr. Moffatt's claim. Mr. Moffatt is self-represented. Air Canada is represented by an employee. For the reasons that follow, I mostly allow Mr. Moffatt's claim. The issue is, did Air Canada negligently misrepresent the procedure for claiming bereavement fares, and if so, what's the remedy? In a civil proceeding like this one, Mr. Moffatt, as applicant, must prove their claims on a balance of probabilities. I assume that's similar to preponderance of the evidence, which means whoever's case is more convincing. You both put on your best case and the judge tries to weigh the two things and make a decision. This means more likely than not. On November 11th, 2022, Mr. Moffatt's grandmother passed away in Ontario. That same day, Mr. Moffatt visited Air Canada's website to find and book a flight from Vancouver to Toronto using Air Canada's bereavement rates. It is undisputed that Air Canada provides certain accommodations, such as reduced fares, for passengers traveling due to the death of an immediate family member. While using Air Canada's website, Mr. Moffatt says they interacted with a support chatbot. While Air Canada did not provide any information about the nature of its chatbot, generally speaking, a chatbot is an automated system that provides information to a person using a website in response to that person's prompts and input. The parties implicitly agree that Mr. Moffatt was not chatting with an Air Canada employee. Mr. Moffatt says they asked the Air Canada chatbot about bereavement rates. They included a screenshot of the chatbot's response, which says in part as follows: Air Canada offers reduced bereavement fares if you need to travel because of an imminent death or a death in your immediate family. If you need to travel immediately or have already traveled and would like to submit your ticket for a reduced bereavement rate, kindly do so within 90 days of the date your ticket was issued by completing our ticket refund application form. I'd be fooled too. It is undisputed the words bereavement fares were a highlighted and underlined hyperlink to a separate Air Canada webpage titled Bereavement Travel with additional information about Air Canada's bereavement policy. Air Canada provided a screenshot of part of what I infer is the hyperlinked Air Canada webpage. The webpage says in part, the bereavement policy does not apply to requests for bereavement considered after air travel has been completed. I address the inconsistency between Air Canada's chatbot and the webpage later in this decision. Relying on the information provided by the chatbot, on November 11th, Mr. Moffatt booked a one-way flight from Vancouver to Toronto, departing on November 12th for $794.98. On November 16th, relying on the same information, they booked a one-way flight from Toronto to Vancouver for $845.38. Mr. Moffatt says on November 11th they spoke to an Air Canada representative by telephone about bereavement rates to determine what the discount may be. They were told the fare for each flight would be approximately $380. There is no evidence the Air Canada representative told Mr. Moffatt about whether or not they could retroactively apply for bereavement rates. Mr. Moffatt submitted their first application for bereavement on November 17th, well within the 90 days requested by the chatbot. Emails in evidence show Mr. Moffatt corresponded with Air Canada throughout December of 2022 and February of 2023 in an attempt to receive a partial refund for their fares. On February 5th, 2023, Mr. Moffatt emailed Air Canada. They included the screenshot from the chatbot that set out the 90-day window to request a reduced rate and confirmed they had filled out the refund form and provided a death certificate. On February 8th, an Air Canada representative responded and admitted the chatbot had provided misleading words. The representative pointed out the chatbot's link to the bereavement travel webpage and said Air Canada had noted the issue so it could update the chatbot. The parties exchanged further emails but were unable to resolve the matter. While Mr. Moffatt does not use the word specifically, by saying they relied on Air Canada's chatbot, I find that they are alleging negligent misrepresentation. Negligent misrepresentation can arise when a seller does not exercise reasonable care to ensure its representatives are accurate and not misleading. To prove the tort of negligent misrepresentation, Mr. Moffatt must show that Air Canada owed them a duty of care, its representation was untrue, inaccurate, or misleading, Air Canada made the representation negligently, Mr. Moffatt reasonably relied on it, and Mr. Moffatt's reliance resulted in damages. Here, given their commercial relationship as a service provider and a customer, I find Air Canada owed Mr. Moffatt a duty of care. Generally, the applicable standard of care requires a company to take reasonable care to ensure their representations are accurate and not misleading. Air Canada argues it cannot be held liable for information provided by one of its agents, servants, or representatives, including a chatbot. It does not explain why it believes that is the case. In effect, Air Canada suggests that the chatbot is a separate legal entity that is responsible for its own actions. This is a remarkable submission. While a chatbot has an interactive component, it is still just part of Air Canada's website. It should be obvious to Air Canada that it is responsible for all the information on its website. It makes no difference whether the information comes from a static page or a chatbot. I find Air Canada did not take reasonable care to ensure its chatbot was accurate. While Air Canada argues Mr. Moffatt could find the correct information on another part of its website, it does not explain why the webpage titled Bereavement Travel was inherently more trustworthy than its chatbot. It also does not explain why customers should have to double-check information found in one part of its website on another part of its website. Mr. Moffatt says, and I accept, that they relied on the chatbot to provide accurate information. I find that was reasonable in the circumstances. There is no reason why Mr. Moffatt should know that one section of Air Canada's webpage is accurate and another is not. Mr. Moffatt says, and I accept, that they would not have flown last minute if they knew they would have to pay the full fare. I find this is consistent with Mr. Moffatt's actions, which included investigating the options for bereavement fares and diligently following up for a partial refund in line with the chatbot's information. To the extent Air Canada argues it is not liable due to certain terms or conditions of its tariffs, I note that it did not provide a copy of the relevant portion of the tariff. It only included submissions about what the tariff allegedly says. Air Canada is a sophisticated litigant that should know it is not enough in a legal process to assert that a contract says something without attaching the actual contract. That's Contract Law 101. You attach the contract to the complaint. Wow, that really is like the first thing I learned in law school. I find that if Air Canada wanted to raise a contractual defense, it needed to provide the relevant portions of the contract, and it did not. So I find that Mr. Moffatt has made out their negligent misrepresentation claim and is entitled to damages. He is entitled to be put in a position he would have been if the misrepresentation had not been made. The measure of damages is generally considered the difference between the price paid and the actual market value at the time of the sale. Mr. Moffatt says that they spoke to an Air Canada agent, and the agent advised them the bereavement fare was approximately $380 in each direction. Mr. Moffatt says they should have paid $760 total for their flights. Instead, they paid $1,630, approximately an $870 difference. In its boilerplate dispute response, Air Canada denies each and every one of Mr. Moffatt's allegations generally. However, it does not provide any evidence to the contrary. Air Canada was best positioned to provide evidence about what the bereavement fare should have been. When a party fails to provide evidence without sufficient explanation, an adjudicator is entitled to draw an adverse inference. Oh, wow. So yeah, this happens. If you are required to provide evidence and you don't provide evidence, then they can rule that the evidence would have been against you and you lost. An adverse inference is where an adjudicator assumes a party has failed to provide relevant evidence because the missing evidence would not support their case. Here I find that if Air Canada had evidence of a different, lower bereavement fare, or should I say higher, it would have provided it. I find that $380 was the bereavement fare's market value. In calculating their damages, Mr. Moffatt uses $380 as the all-in cost of each flight, Since Mr. Moffatt says they were told the fare was $380, I find that does not include the additional costs of taxes, security charges, or airport improvement fees that they had to pay. Their original tickets contained all of these costs, and I find that bereavement fares would have as well. For the flight from Vancouver to Toronto, Mr. Moffatt paid $695 plus taxes. The total there is $474.23 with the bereavement fare plus taxes. So then they recalculate, and the new damages after taxes are accounted for is $650.88. Air Canada argues it would have provided a $200 coupon as a gesture of goodwill. I infer that Air Canada argues that it is entitled to a $200 set-off against any amount it may owe Mr. Moffatt. However, Mr. Moffatt says they did not accept said offered coupon, and Air Canada has provided no evidence to show otherwise, so there's no set-off or offset. The Interest Act applies, and another $36.14 of interest is charged. The rules will generally give an unsuccessful party the requirement to reimburse the successful party. The court will follow that rule, and so another $125 in fees reimbursed to Mr. Moffatt, for a total of $812.02 that Air Canada would have to pay, and probably has paid to Mr. Moffatt. The CBC did an article on this. In an argument that appears to flabbergast a small claims adjuster, the airline attempted to distance itself from its own chatbot's bad advice by claiming the online tool was a separate legal entity that is responsible for its own actions. This is a remarkable submission. It makes no difference whether the information comes from a static page or a chatbot. Yeah, same thing that we read before. So that's a remarkable story. Lawyers are expected to make all of the defensive arguments. Sometimes it's called the spaghetti at the wall defense, but it's good legal practice in general to identify all of a client's defenses and make and allege all of the client's defenses. And then, yes, you might have to work out which defenses you can prove, which defenses you are allowed by that are properly counter to the plaintiff's claims. But there is a limit. You remember the affluence argument in I think it was Texas court, that a child grew up so wealthy that they don't know the difference between right and wrong. It was never taught to them properly. And that's some kind of legal defense from them being punished for their crimes. There was the Disney defense where Disney said, you signed up for Disney Plus, therefore you can't sue us for your wife dying of anaphylactic shock because they gave her food with allergens in it that she was not allowed to have after she told them, you can't give me food with this allergen in it. I think it was peanuts. So it's not that surprising that a lawyer would make an argument that a chatbot, that it's reached some level of sentience, that it's not subordinate to a larger entity, and instead it's responsible for itself. And what? You put the chatbot in jail? How is the chatbot supposed to pay for Mr. Moffatt's damages? So it's, on one hand, totally expected that a lawyer would make such a claim, such a defense, but also unbelievable that they would try and say that a chatbot, not even a really good one, was equivalent to a human in legal standing. So no, we are not there. Chatbots are not the equivalent of humans in legal standing. Only for some reason corporations are. I still have problems with this. Corporations don't have the need to eat and feed themselves and sleep in places and yada, yada, yada. Corporations are slippery humans. They are less than human, and they should not be treated like humans. But I do understand the corporate fiction of working with a corporation the same way that you would work with a person as a client legal entity. But here, Air Canada is the legal entity that has responsibility for its chatbot. Duh, as you always do. I hate the deflection. I really hate the deflection. People need to take responsibility for their actions. If we all took responsibility for our actions, the world would be a much better place. Instead, we do this thing with deflection where we try to get away with as much as possible. And I mean we generally, as a society. I'm not trying to blame any one person, viewer. So I'm appalled that Air Canada would go so far as to make such an idiotic legal argument that has absolutely no place in modern human society. It's never winning. It would never win. That's not a, there's really no support for it being a novel legal argument. Remember, novel legal arguments are allowed, but they have to be supported by something. So you can argue that the law shouldn't say what it says, or it goes too far, or it doesn't go far enough. You can say that it should be different than what it reads, but you must have a basis for that. At least under American law, I'm assuming this philosophy applies everywhere. Anyway, so yes, I thought that was an interesting legal situation for you, and I wanted to get your thoughts in the comments below. Thank you for your support on patreon.com/ljfrench with floatplane subscriptions and through YouTube memberships. I love you all, and I'll see you in the videos that drop. I'm Leonard French, your favorite copyright attorney. Bye.